Hello, this is the AI Lab. Today it's my pleasure to welcome Ariadna Matas. Ariadna is Policy Advisor at the Europeana Foundation, an independent, non-profit organization that stewards the common European data space for cultural heritage and contributes to other digital initiatives that put cultural heritage to good use in the world. The reason? An article entitled AI Opt-outs. Should cultural heritage institutions disallow the mining of cultural heritage data? Let's hear what Ariadna has to say. So, Ariadna, in your blog post, you talk about the 2019 Copyright Directive. Can you give a brief overview of how that directive changed the landscape for cultural heritage institutions in terms of what is called text and data mining, or TDM?
Sure. Thank you for the question. So I can share some of my personal impressions on this aspect. And just so we know that I'm speaking, so my answers are focused on some of the implications I see in the cultural heritage sector, meaning libraries, archives, and museums who have collections, let's say permanently held, that they digitize and make available online to some extent whenever possible. The answer would probably be slightly different if I was speaking about research organizations such as university libraries, so focusing a little bit more on museums, libraries, and archives in the cultural heritage sector. But with the 2019 directive and the provisions on text and data mining, my expectation, and I think the expectation of some people in the sector, was that it would open up a lot of possibilities for cultural heritage institutions to continue fulfilling their public interest mission, now with the help of a technology that can unlock a lot of possibilities. And for example, I imagine cultural heritage institutions being enthusiastic about being able to provide data sets that can be used as input for training models that can be used on various activities. So that was one of the expectations I had with the adoption of the 2019 directive. However, in practice, what I'm seeing, and these again are some impressions from some initial changes and in some institutions, is that first of all, many cultural heritage institutions make use of text and data mining techniques. First of all, to conduct their own activities. So there's some institutions making use of tools to be more efficient in the cataloging process, for example, because there's a model that is much quicker than a human would be in identifying, for example, relevant people's faces in a collection of photography. So they are able to tag it and catalog the materials and make these materials easier to find and study for the people that come to the cultural heritage organization. So first big use of text and data mining techniques, which was already probably emerging back in 2019, is to facilitate cultural heritage institutions to conduct their day-to-day work. However, it's much more rare to see cultural heritage institutions preparing data sets for the public to use in text and data mining activities, or at least as far as I have seen. There's a project that Europeana has participated on, the AI for Culture project, that is a really good example of the cultural heritage sector getting organized into making that possible. So through this project, the project partners make available tools, but also data sets that cultural heritage institutions and others can use through text and data mining technology. So that's really positive, but I am not seeing as much of that as I was imagining myself. And then what's really starting to feel a bit strange to me, the direction that blog post was taking, is that we're seeing more and more institutions being probably unnecessarily cautious about this big debate and being a little bit more like leaning towards putting barriers to the use of some of the data they make available for text and data mining purposes, rather than, on the contrary, emphasizing the fact that this data can be used and encouraging the use of that data. So that's a little bit on the landscape of what I'm seeing practically at the moment.
So you mentioned that they're putting some barriers. Why do you think these, or at least some cultural heritage institutions, are choosing to opt out of data mining, despite initially supporting the exception and the adoption of that exception in the copyright directive? And what are the key ethical and legal challenges that this entails?
So the reasons for deciding to opt out are, there's probably many of them, and it's a little bit difficult to know at this stage. So I'm seeing a couple. One of them is, and that's probably the only fully legitimate reason, is that whomever holds the rights to the material in question has asked the cultural heritage institution to place an opt-out. But it's worth reminding ourselves that a library, a museum, an archive holds so many different types of materials, many of which in the public domain, simply never protected, or on which copyright has expired. Administrative decisions, like documents from the notary, pages and pages from newspapers, magazines, books, but then also amateur photography, film that has never been distributed, sound recordings from nature. So we're talking about a very diverse type of materials, some of which is subject to copyright, and this copyright very rarely belongs to the cultural heritage institution. And the cultural heritage institution, unless we're talking about a contemporary art museum or an archive that deals with the donation of certain collections that are relatively contemporary, these cultural heritage institutions are very rarely in touch with the rights holder, with whomever might actually hold the rights on some of these materials. So it's a little bit difficult to actually enforce a rights holder's will to opt out cultural heritage data from being mined, because it's very difficult for the institution to actually know who the rights holder is and what the rights holder wants. So I suspect some institutions are starting to place opt-outs because they've received this indication from rights holders, but that's a very rare case in reality. A situation in which the institution is simply enforcing the decision that is perfectly legitimate under Article 4 of the directive to place an opt-out. And I think many institutions have template contracts that, for example, the donor of a collection signs when handing some content over to the institution, that foresees some of the conditions under which the institution will preserve and make available the content. And I don't think these contracts, which were signed maybe sometimes like 10, 20 years ago, foresaw the option of placing an opt-out. So even when the institution was in touch with the rights holder, this didn't get expressed at the time. So let's say first legitimate reason for placing an opt-out by a cultural heritage institution is because the rights holder has asked for it, but I suspect this will be very rare. Sometimes institutions are in touch with collective management organizations who make such a decision on behalf of the rights holders they represent, but collective management is not always the system that institutions can rely on, because they're dealing with large collections with repertoire that is not always represented by this type of organizations. So that's another situation in which I think there's a little bit of a debate on the extent to which the collective management organization can request the opt-out on behalf of the organizations it represents, of the people it represents. But I see this could be another reason why an institution would want to respect the rights holders' will and place an opt-out. Other than that, which again is really niche, I think there's a lot of cases in which the institutions in the cultural heritage sector are starting to wonder, should we put in place opt-outs, but as sometimes without really understanding that there's a legal framework for text and data mining, and that the opt-out should only be exercised by the rights holder. That is a decision that only belongs to that person or institution, and generally not to the cultural heritage institution. But I think there's like sort of a moral debate going on because of this very polarized debate that exists around AI, and they wonder, we are safeguarding this heritage, we're making it available to people. Do we have a responsibility to protect it from some misuse? Now, I find that part a little bit dangerous, because there's some amazing things that could be happening with this content, but they don't get all of the mediatic attention that the bad players get. And so by opting out some data, or placing restrictions in some other way for cultural heritage data to be used, we'll be missing out on all of the positives just because of a fear that there are some negatives. So I find that part a little bit dangerous, especially in the cultural heritage sector, where we're mostly publicly funded and we're mostly trying to fulfill a public interest mission. I think cultural heritage institutions do have a responsibility to safeguard access to this information and its possibility to be used.
I see your point about your concern, knowing that at the end of the day, cultural heritage institutions are there for cultural diversity and making sure that as much culture as possible is accessible to as many people as possible. So I can see why you consider there's some ethical issues maybe, or at least some concerns when it comes to not giving access to certain content out of maybe cautiousness to a certain extent because of the AI phenomenon and how it's perceived. What I also liked about your blog post is that you take into you look at the smaller ones, the smaller players, and to you, what could be the broader implications of these opt-outs for research, smaller institutions, and more generally, as you mentioned, the open access to cultural content?
Yeah, that's interesting, because I have the impression that what some organizations are thinking of and what's motivating their decision to, or started their, maybe not yet a fully formed decision, but their tendency to think that they should be blocking access for certain purposes, is that they don't want to support the big players in I don't know, in the climate implications of some of their activities, in some of the unethical practices. Well, I don't disagree with some of that, but yeah, I think these bigger players can find access. Maybe they already have access to the data and they've made copies. Who knows? Maybe they wouldn't be scared of an opt out, and they would use it anyways. I mean, it's a big mystery, and I don't think opting out by a cultural heritage institution is what's going to weaken their maybe monopolistic practices. On the contrary, the smaller players who cannot maybe pay some of the fees or negotiate some of the contracts, they are the ones who will be suffering the most from not accessing the data. So I think the institutions who have the power to make this data available to the public also have a responsibility to think about all of those and the implications of their possibilities to access data and use it in many positive ways, if they decide to stop access in certain ways. Maybe it's a matter of finding some more fine-grained solutions, but at the moment I don't think they're fully available. So there's the risk on taking a very strong decision and a big step at the moment in disabling the possibility somehow of applying text and data mining techniques on cultural heritage data. Maybe later on there will be a system to safeguard some fair remuneration in some specific situations without harming the smaller players, or there will be a system of opting out of only certain types of activities in a way that is much more granular than no TDM. And I see that some institutions are so the only situation in which I would understand an institution taking some measures, not sure which yet, because again the opt-out is not necessarily their decision, but the only situation in which I would understand an institution taking some measure is that I think some are experiencing some kind of bad actors doing very aggressive crawling that might affect the server capacity of the institution. So when the practice itself hampers the activities of the institution and the extent to which they can continue providing a service to everyone else, then it probably becomes a problem, because it makes it more difficult to provide a public service. But there's many other situations in which that doesn't happen, and I think then we need to be a little bit more careful.
I mean, thank you, Ariadna. I think that those are all very interesting points, and not being a copyright expert myself, I hadn't even thought about who is allowed to give an opt-out and who shouldn't give an opt-out. So thank you for clarifying that point, that opt-outs lie with the right holders. And also the fact that TDM opt-outs are very blunt instruments to a certain extent. It's yes or no to all TDM, good, bad, small, big. You're basically opting out of all of it in one go. So I hear you when you say that maybe more granular solutions would be, um, you know, would need to come out in the future so that people can say, I don't mind my data being used for this, but I do mind if it's used for this. I can see that would probably make more sense than a polarized yes no, but I guess that's what the law gave us at the moment with Article
Yes,
4.
yes, exactly.
So let's hope there are guidelines. Thank you so much for writing this blog post. It was really a useful read, and I think it gave a perspective that we don't read much about, which is the cultural heritage institutions perspective. And please continue sharing your thoughts in the future.